So I would like to welcome all of you for this interesting session. We have Dr. Lata Venkatram and Dr. Sushila Rani, both of them past presidents of BSOG, to moderate and chair this session. So over to you, ma'am. Dr. Sushila Rani.
Yeah, thank you. I'm just waiting to see if Dr. Hitesh has managed to log in through the computer. Anyway, in the meantime, I'll make his introductions. Dr. Hitesh Bhatt actually is a doctor practicing advocate. He is the medical legal consultant since the last 20 years. That means he's been practicing only law. And he's a medical legal consultant at Wadia Maternity Hospital and Central Railway Hospital. He also has a legal firm of which he is a partner called the B&S Medical Legal Consultancies, and he's been the past chairpersons of the Ethics and Medical Legal Committee of POCSO. He's been giving talks all over the country on medical legal topics, especially regarding consent, etc. And he has also served as the office bearer for IMA and various other OB-GYN societies. Another important dimension of his is that as a life member of the Film Writers Association Mumbai. So anybody who wants to gain access to Mumbai Bollywood can know how to go to. Now, Lata, yes, I hope.
I think so. I thought you had already approached him.
No, I'm just trying to make my way. Dr. Hitesh? I'll just see if he's logged in.
Yes, madam.
Yes, Dr. Hitesh, glad to have you. I just made your introductions.
Okay, madam.
What happened?
So, you want me to start, madam?
Yes, certainly. I just made the introductions, and basically, Dr. Hitesh, the reason why we wanted to have this webinar is because we thought as obstetricians and gynecologists, all these years, we were sort of complacent about the POCSO Act. We thought, it involves a very small section of the society where the children are sexually abused. But then now we know that doctors as such, and most importantly, the OB-GYNs have some implications because of the POCSO Act after the 2019 amendment, etc. So to throw more light onto the subject and to give some clarity in our minds about the POCSO Act, we request you to talk on the implications of POCSO Act on the OB-GYNs.
Okay. So first of all, thank you very much for inviting me and allowing me to share my views with you all. And I hope I'm audible, right?
Yeah.
So
Yes,
let me first go through the certain the provisions of the POCSO Act, like what it is. We must know that what is actually the Protection of Children from Sexual Offences Act. That is the act enacted in 2012. And in short, we can call it POCSO POCSO Act. That is what is the nomenclature. So the full form of POCSO is Protection of Children from Sexual Offense Act. This is the act. Now, what are the important things they have defined in this act? The penetrative sexual assault and sexual harassment. They have segregated these two things. Now, and one more important thing is there in the act is they have defined a child. Any person less than 18 years of age is child. Now, less than 18 years in the law, whenever there is some say time limit, when they say 18 years completes on the 18th birthday, midnight 12. That is how the time is counted. It can't be plus or minus 2 days, this, that. It is not that loose. In law, if it is 30 days, it ends on the 30th day, midnight 12. If it is 7 days, it ends on the 7th day, midnight 12. That is how the time is counted in law. It is not like us, that conference is starting at 10. So people will come at 11 and then 11:30 we start. It is not like that. In law, the boundaries are fixed. So that we have to understand. Now, a person is said to commit penetrative sexual assault if the penetration of the penis in the vagina, mouth, urethra, or anus of the child with himself or with any other person. Insertion of any object or part of the body in the vagina, mouth, urethra, or the anus of the child with himself or with any other person. See, all these terms, they have taken exactly same from the 376 of the rape of IPC. In there also, they have now changed the terms as far as the sexual assault is concerned. Previously, before Nirbhaya case, the rape of the definition was there was a requirement of penetration into the vagina. That, and similarly, here also they've said insertion, they've said that, they've also said insertion of any object, so it need not be the penis, and manipulation of any part of the body of the child in order to cause penetration. So
Dr. Hitesh, we cannot hear you. Maybe Dr. Hitesh? Dr. Hitesh? Oh, he's frozen.
Yeah, I think.
also,
Dr.
they've-
Hitesh, Dr.
We
Hitesh,
lost him.
Hello?
we could not hear you for quite some time. Maybe you can switch off your video and so that, we can listen to you and subsequently, because maybe your signals are not very strong.
Okay, it is from the hotel basically.
Can most of the delegates switch off the video? The network quality
No,
would be better.
it will not make any difference. I will
That won't make any difference, Lata.
So now, can you hear me now?
Yeah, very clearly, very clearly.
Okay. So it says that manipulation of any part of the body of the child in order to cause penetration into the vagina, mouth, urethra, or anus of the child with himself or with any other person. So the penetration is not important to denote a sexual offense. The same is true even in the IPC 376, that is the rape. In that also, they have said this thing. They have mentioned this thing, that even manipulation of the body part in order to do penetration. In older times, before Nirbhaya case, the penetration was mandatory to have an offense of rape. But now it is not so. And same is the definition in this POCSO Act also for the child. So instead of women, the word used is child, but the definition, the wording is same. And also they've added this, that if somebody applies his mouth on the penis, vagina, urethra, mouth, or anus of the child with himself or with any other person, that is also a sexual assault. So sexual assault is defined just the way the rape is defined in Indian Penal Code. So that is sexual assault. The sexual assault also includes touching of the vagina, penis, anus, or breast of the child. Make the child touch vagina, penis, anus, or breast of the child. Any other act with sexual intent which involves physical contact without penetration. So all these are the sexual offenses. Here they have given one explanation also. The sexual intent is the most important ingredient. This is very important. So if somebody touches without any intention or sexual intention, then it is allowed. But otherwise, with sexual intent, if somebody is touching the body part which are described, that is considered as sexual assault. And these offenses are gender neutral for the culprit as well as for the victim. This is also very important. When it comes to rape, under 376 of the IPC for adults, it is mentioned that when a man commits all these things on a woman, it becomes a rape. So rape is done only by the man on a woman when it is adult, when it is under IPC. But under POCSO Act, both the culprit as well as victim can be a male or a female. So it is gender neutral when it is under the POCSO Act. So even with the boy, all things can happen and it is still a sexual offense. Now, sexual harassment is also defined. Sexual offense and sexual harassment are the two things which are defined in the POCSO Act. Sexual harassment they have defined as sexual harassment of the child with sexual intent. And what is sexual harassment? Utter word or make any sound to be heard by the child, showing any object or body part, or making any gesture aimed at a child, making a child exhibit her body, or enticing or threatening to use a child for pornography. So all these things are sexual harassment. Now they've also defined aggravated penetrative sexual assault and aggravated harassment. So first thing is sexual harassment. Second thing is sexual assault. Now in both this, there is aggravated form. So there is aggravated sexual assault and there is aggravated sexual harassment. What is aggravated sexual assault and what is aggravated sexual harassment? They have said when it is done by armed force or security force, public servant, person in position of trust or authority of the child, by gang, child below 12 years of age or relative, etc., then the same offense becomes aggravated. So if it is done by say the person of unknown person, then it still is a sexual assault. But if it is done by the relative or the age of the child is less than 12, or if it is done as a gang, then it becomes aggravated offense. So that also we have to understand. Now, what is the punishment? The punishment they mention is for penetrative sexual assault, 7 years of life imprisonment. Aggravated penetrative sexual offense, that means by the relative, armed force, police, or the person of trust or family member, it is 10 years to the life imprisonment. Here it is 7 years to life imprisonment. So minimum 7 years and maximum is life imprisonment. For relative, it is minimum 10 years and maximum is life imprisonment. Sexual assault, for punishment, otherwise in sexual assault, it is 3 to 5 years. And aggravated sexual assault, it is 5 to 7 years. So that is how the various punishments are mentioned in the POCSO Act. Now, section 19, that is most relevant for us. And what it says that it is mandatory for any person having knowledge about the commission of an offense under this act. So we have seen what is offense under this act. Now, what is important for a doctor? It is mandatory for any person having knowledge about the commission of an offense under this act to report to the special juvenile police unit or the local police. This is what is the mandate for a doctor. So if a girl or boy, whosoever comes to you, mostly we are gynecologists, so girl will come to us. If she is less than 18 years of age and she is found pregnant, she cannot become pregnant without an intercourse naturally. So any intercourse with a child less than 18 years of age makes it penetrative sexual offense under section 4. And the punishment for the same is 7 years to life imprisonment for the assaulter. So that is the provision. So if you come to know about this, it is your duty to report it to the special juvenile unit or the local police. That is what this section says. Also, the gynecologist, general practitioner, venereal disease specialist, all this have to report it to the police. Also in section 21, it says that punishment for failure to report or record a case by any person being in charge of the company or an institution, 1 year of imprisonment with fine or both. This offense does not apply to a child. If child knows about his friend having sexual or having suffered sexual assault, the child will not get punished because he was having the knowledge. But anybody who is more than 18 years of age and has this knowledge, then he is duty bound to inform under section 19 to the police. If he fails to do that, he is liable for the punishment of 1 year of imprisonment under section 21. So for a gynecologist, it is mandatory to inform. Section 22 also says that punishment for false complaint or false information in respect of an offense committed under section 3, 5, 7, and 9, solely with the intention to humiliate, extort, or threaten or defame him. So if you report wrongly under any of this intention to humiliate, to extort, to threaten, or to defame, then also there is a punishment, and that punishment is for false complaint or providing false information against a child, knowing it to be false, thereby victimizing the child for the of the offense under this 6 months of imprisonment or fine or both. So nobody should give wrong information, but whenever there is a correct information, when she is pregnant, naturally there is a sexual assault. Without intercourse, nobody becomes pregnant at that age, at 18 years of age. So it has to be reported to the police. Now, if you see the procedural part of it, if some such child is brought to you for examination, now what is the procedural part of it? Immediately after sexual assault, if somebody comes to you, then recording of the statement, language of the statement, what to record, how to record are the procedural part. And that is there. This is that is there in the POCSO Act, but that is not the matter of discussion at present. The thing is, it is same as the rape. You have to have all the evidences collected. You have to collect various samples. You have to collect various, you have to take consent. The child has to be examined by a female doctor, and you have to collect the evidences. You have to take consent of the parent, and all the various swabs you have to take. You have to take vaginal swab, you have to take anal swab, you have to take the nails, you have to take hair. You have to collect all these things, and you have to make the evidence. When you terminate the pregnancy, you have to inform police that we are terminating the pregnancy, and the product of conception, if you want for the evidence, we will keep it ready, and you can come and collect it within 72 hours. So you have to inform police about that also, and it is duty of the police then to collect that and submit it for the DNA testing for paternity. Now there is amendment in the MTP Act also, and we have to understand some part of the MTP as well. We know the old MTP Act. Now, what are the changes in the new MTP Act? I'm going to focus only on that, and then we will have some question answer so that you can ask me anything which is there in your mind, and we can solve it to your satisfaction. Now, in new MTP Act, they've added medical boards. What is medical board? Medical board means it is constituted under a particular section of this act, and the board shall consist of following: a gynecologist, pediatrician, radiologist, or sonologist, and such other number of members as may be notified by the Gazette. So there will be a board, medical board. What is the function of the board? We will see it in some time. They have also defined termination of pregnancy, but vaguely. They have defined termination of pregnancy means a procedure to terminate a pregnancy by using medical or surgical method. So they've included the medical part. Many people had that misconception in their mind that by giving oral pills, they are not committing any MTP. So they were not following the norms of the MTP. But giving tablet to terminate the pregnancy is also a termination of pregnancy, and that is well covered under the MTP Act. Now, what are the changes in both this act? In the previous act, up to 12 weeks, advice of one doctor was required, and in new act also, up to 12 weeks, advice or the opinion of one doctor is enough. Up to 12 to 20 weeks, in the old act, we had provision of taking advice or opinion of 2 doctors or more than 2 doctors. While here in new 2021 act, they have said in the advice or opinion of only 1 doctor or 1 RMP is enough up to 20 weeks. Between 20 to 24 weeks, it was not allowed in the old act. But in new act, they have said that it is allowed, termination of pregnancy is allowed between 20 to 24 weeks, but 2 doctors have to give the opinion for and this is allowed for only some category. What are these categories? Rape and congenital anomaly. These are the 2 main aim. For failure of contraception, you cannot terminate between 20 to 24. Between 20 to 24, only 2 indications they have given majorly. One is rape and second is anomaly. An anomaly which are not compatible with life. This type of anomaly. For polydactyly, you cannot terminate at beyond 20 weeks. So they have also said that it has to be generally known to cause the death. It should be lethal anomalies. And that is how they have given the indication. More than 24 weeks. It was not allowed in the older act. But in new act, they have said if medical board is of the opinion that a fetal anomaly is of substantial kind, which can lead to death or which can lead to a very poor life in future, the board will allow. And there will be some list of the diseases in which the board will allow. So with the permission of board, even beyond 24 weeks, we can terminate the pregnancy. Anytime during the pregnancy, that is also allowed. When it was in old act also, in new act also it is there. By opinion of one doctor, if immediately necessary to save pregnant woman's life. So there has to be life-threatening emergency. And in that case, you can terminate pregnancy at any weeks of gestation by opinion of only one doctor. But the thing is, the onus is on the doctor to prove that it was immediately necessary to save pregnant woman's life. For infringement of the privacy, in the older act, the punishment was 1,000 rupees. But in new act, imprisonment of 1 year or fine or both. That is there in the new act. And contraceptive failure as a reason for termination. In the older act, it was available only to the married women. But now it is available to unmarried and married women both. So they have, because the old act was of 1971, and at that time they were not, society was not mature enough, and the lawmakers were not promoting, they were not seen to be promoting sexual promiscuity. And that is why they put this failure available to married women only. But now they know that the social norms are changing, people are getting married late, and sexual desires do come at certain age. And that is why they have added this clause that available to unmarried and married women both. Now, the norms for the registered medical practitioner whose opinion is required for termination of pregnancy at different gestational age shall be such as may be prescribed by the rules under this act. That is what was the told in the act. So the rules came, and under the rules, they have said that what are the norms for termination of the pregnancy by oral tablet. They have added, it was previously up to 7 weeks. They have made it up to 9 weeks. And for that, the RMP must have training of abortion by tablet on his own in 5 cases and total 10 cases, then he can go ahead and do it. For other things like up to 12 weeks and beyond 12 weeks, the training and all these things have remained same. Now, there are I think we will take it in this case, we will take it in the question answer session. This is a beautiful case where a signature of the husband, whether it is required or not, that was discussed. So that we will take it with the question and answer. And I think whatever information which is required for the purpose of learning this thing, I think we have to now come to the question and answer session. That much information I have given, and you don't require any further information as far as the POCSO and MTP is concerned for our normal day-to-day practice, right? So I think we will keep now this session open for the question and answer, if you are all okay with that, right?
Yeah, I
so
think
that we will give more time for the question and answer, right?
Yeah, I think we'll take the question from Dr. Sunita Shikokar. Please stick to the topic kindly. Thank you.
Can they put the questions in the chat box so that we can address the questions instead of?
Yes.
Yeah, probably they could.
First, we will take questions related to the topic. Then otherwise, if somebody has a big concern, they can ask anything under the sky for medical legal problems.
I have a question related to POCSO.
Yes,
Just 1 second, Sushila. Can
Yeah.
we have the question from Dr. Sunita, and then we can follow it on? Thanks.
Yeah.
Sure.
Has it appeared in the chat box?
No, they have raised the hand, so we will allow few people to interact. That would make it more interesting.
Sure.
Yeah, can you hear me?
Yes,
Yes.
please.
Yeah, it was really nice information. In a small clinic run by the gynecologist, when we are doing the medical MTP, do we need a certificate from a particular state that, okay, you are allowed to do the MTP, medical MTP?
Now, section 5 of MTP rule, that is not changed. It said in that time also, in old MTP Act also, it was mentioned that if you want to prescribe a medical termination of pregnancy pills up to 7 weeks, and now they've made it up to 9 weeks, you can just have an access letter from the center which is having registration. Now, what is written in that access letter? In case of emergency, you will be authorized to utilize the facility of that center. So you
Okay.
have to take an authority letter from your friend who is nearby and who is registered under MTP Act for up to 12 weeks or 20 weeks, mentioning that I, Dr. So-and-so, is having a MTP registered center at this address with this number. I allow access to Dr. So-and-so, who is prescribing MTP pills up to 9 weeks from her center, which is located at this place. That letter you have to display in your clinic along with the registration of that doctor, so that if somebody asks you, you can show that this center has given me the permission. So that letter you keep with you, and you can prescribe medicine up to 9 weeks of pregnancy from your clinic.
Can we
Instead of
stick
a-
to, sorry, can we stick to questions on POCSO, please? Yeah,
Okay.
thank you.
Dr. Hitesh,
Yes, madam.
see, when it comes to POCSO, supposing for some reason we are not aware that the girl is less than 18 years, supposing she comes and gives us a false age that she say 19, 20 years or whatever, and then we get to know that she's much younger, do we still need to inform the police? This is one question, because recently I had a girl who came pregnant with her mother, and when she registered with her, the date of birth that she gave amounted to 19 years, but when she gave the Aadhaar card for the purpose of ultrasound, it was 17 only. So then I had to inform the police, and then it became a messy affair. The
So-
police then accused that boy, and then they arrested, and they said he will be imprisoned for 10 years. So this becomes fairly messy, isn't it?
But see, the first thing is law is law, right? In our medical ethics, we have been taught that first do no harm. That is what they teach us. But today the scenario has changed. First do no harm to yourself. That is the message now. So you have to think of your safety first. That is first thing. Second thing, when it comes to age, age is a biological occurrence. And we are scientists, or we are science students and of biology, right? We are students of biology. So age is a biological occurrence. So we have to have highest accuracy as far as the age is concerned. Now, how do we, biologically also, you can ascertain the age. There are various methods to ascertain the age if person is not having any Aadhaar card or anything. So you have to be sure, especially when person is at the borderline age. You cannot use the age writing 18 or 19 at your benefit, because by that way, you are covering the crime. That is how the law will look at it. So you have to inform police, you have to get the Aadhaar card. And also, I would like to narrate one incident here that is from the Maharashtra. One doctor, he took Aadhaar card of the patient. Now, she gave Aadhaar card with, say, the name was Kavita Patil. I'm just giving example, Kavita Patil. That Aadhaar card was given. But in the case paper, she gave her name as Kavita Shaha. She gave another surname. Doctor took the Aadhaar card, and the case ultimately did MTP. After a few months, the police came and they said she was minor. Doctor presented this Aadhaar card. They said this Aadhaar card was taken by me, and she had given this to me. Now the surname is different. She said different surname to police station also. Aadhaar card was not self-attested by the person. You always have to take self-attested Aadhaar card. Now the police is telling that doctor that you have put Aadhaar card of some Kavita Patil, which is your patient, to avoid your arrest. Because you are party to crime, you have not informed us. So you have put somebody, because we get the patient with the same name. So many patients will get in the same day. You will have 5 Kavita, 5 Savita. You will get such patients. So they are telling, police is telling that you have put someone else's Aadhaar card. So always take Aadhaar card, first thing. And second thing, always take self-attested Aadhaar card. You ask the person to say, and whenever we give Aadhaar card for SIM card or for bank or anywhere, nobody will take it without your signature. I'm in a hotel right now. I stay in hotel for 25 days in a month. Nobody allows me entry without Aadhaar card. I don't look like less than 18 years. Still they take Aadhaar card, first thing, and they take my signature over it. So you have to be that much diligent. The questions asked in the court when I present such cases, they say, doctor, आपको इतनी भी अक्कल नहीं है, ये छोटे लोग भी आधार कार्ड लेते हैं. Why you are allowing somebody without Aadhaar card? And there is no emergency in that, right? So we have to first make a safeguard for ourselves. We have to take Aadhaar card. We have to identify the person, and then only the MTP should be done, especially when they are at the borderline age.
If we are not competent to assess the age, that is, if we lack the knowledge for assessing the age, how would we be looked at in the court of law, or do we take the expert guidance from forensic experts? Or
yeah, you can take that also,
etc.
but before sending it to forensic, you can always ask for the sum of the registration, because those who are 18 years of age now, for them the birth registration was compulsory. When the birth registration was not compulsory, those people are already adult now.
Well, rural areas, you still have this problem.
So they still have Aadhaar card. They still have Aadhaar card, and that is how they are getting subsidy. For government subsidy, they have Aadhaar card. And if they don't have Aadhaar card, then you just send them to either government hospital, or you ask them to get some kind of proof for their age.
So,
and they will definitely get it.
If we did not get the Aadhaar card, you send them to government hospital, is it?
Because
it is not,
especially when they are at the borderline age. If she's 35 years of age, don't insist on it. Fine.
Yeah.
But sure, if she is at borderline age, first see your you don't cause harm to yourself. See your benefit. And there is one case of Dr. Saili Raiban from Mumbai. There also the same thing happened. What happened just last year? She did one MTP. The patient presented with her uncle when she said she is 20 years of age. She terminated the pregnancy. Nothing happened for 4 months. Then she had some problem with the boyfriend or whatever. She told at home, and her mother filed a complaint against the person. So, and she said that my daughter is 17 years. So the police came and arrested that doctor, that gynecologist, and she was in police custody for 3 days. Then she came to me. I got her bail. She was not even getting bail. I got her bail, and she was out on 14th January 2021. I got her out of the police custody, and recently, just 2 months back, we won the case and we got her discharged. So the thing is, it took 1 year for her to get discharged, first thing. And second thing, she was in jail for 3 days. Police can keep you for longer also. But we presented, and there were lacunas from police procedure, so we got some benefit. So you have to be very careful. If you do not fear jail, this lecture is not for you. But if you have that fear in mind, then you must be very careful. But jail is a good place. Let me tell you that also. They give you food, they give you clothes, they give you money for the work you do, and you get to see your spouse every 15 days. So it is basically a good place, right?
Yeah, it is better than labor ward then.
Yes.
Yeah.
Dr. Hitesh,
Is Aadhaar card, there is a question on the chat box. Is Aadhaar card, if not produced, can we consider any other document?
There is a list of documents for the age proof. It can be passport, it can be Aadhaar card, it can be birth certificate, it can be school leaving certificate. So you can go to government website and you ask, you write there the age proof, government approved age proof. You will get list of the documents and you can use any of those.
Yeah, sending them to government hospital doesn't mean that we are, I wouldn't say negligent, but we are not
Absorbing us.
responsible. Yeah.
Dr. Hitesh,
At least why government? To ascertain the age. Government has all the department. Government
Okay.
hospital has dentistry. They will do
Yeah.
dental X-ray. Government has orthopedic. They will do the knee and all joint. They will check. Government has forensic department. That is why I'm telling government,
Yeah.
so that they will ascertain the age.
Yeah.
Not to
Dr.
avoid the
Geetika-
liability. You are sending them to ascertain the age.
Yeah.
Otherwise, if it is there in your knowledge, now again, I will tell you, if you have knowledge that she is less than 18 years of age, and just to avoid police information, you are sending her to other place, you are still liable. Because the law says, if you have seen the section 19 of POCSO Act, it never reads, if you terminate the pregnancy, you have to inform police. If you have knowledge that sexual assault has happened, you have to inform the police. So by referring her to some other place, you are not avoiding your responsibility. You are actually sending her not for termination, not to avoid your responsibility, just to ascertain the age.
Right.
Okay,
Okay, Geetika Jain has raised her hand from a long time.
Yeah.
Could we have her, please? Thanks.
Good evening, sir. Good evening, ma'am.
Yes. good evening.
Ma'am, my question is again, sir, from about the MTP Act only. See, you mentioned that only up to, I mean, after 24 weeks, only a medical board will decide if the congenital anomaly is incompatible with life or not. So supposing a case comes to us with, I mean, some anencephalic fetus is there of 30 weeks. So are we allowed to terminate it
See,
without
there are
the
two views.
medical
There are
board?
now we have to send it to medical board, because
Yeah,
they have
because
said-
earlier we were terminating. Earlier there wasn't
earlier we were
any issue with
terminating
it.
because it is, see, there are two views about it. The first thing is, you are allowed to do the treatment. Now, if you open any textbook, which used to say that for anencephaly, the treatment is termination of pregnancy. But for other anomalies, like cardiac anomaly or any other anomaly, they have given various operations. Show me one textbook which says that for, say, cardiac anomaly, the treatment is termination. They have said
Yes, sir.
various operations.
Yes,
They have-
particularly
they-
that is why I'm asking about an
So,
anencephalic
For
fetus.
any other anomaly, the treatment given in the medical textbook is operations. But for anencephaly, they have not mentioned any treatment. The only treatment but now the textbooks are also changing. They are changing their words. In textbook now they are writing termination of pregnancy if the law of the land allows. They have added this word now. So it is better to send them to board. Why you want to take responsibility? Right? Let the government decide. And anencephaly will be there in the list of anomalies which should be allowed for termination.
Dr.
Right.
Hitesh, if a married girl who's less than 18 comes for antenatal checkup, not for termination, if there is a married girl who is less than 18 and she comes for antenatal check, we still need to inform the police?
Again, I'm telling you, madam, the law section 19 says you have to inform sexual assault. It is the intercourse you are informing to the police, not the pregnancy. Pregnancy is the result of the crime. Pregnancy, becoming pregnant is not a crime. Having sexual intercourse with a minor is a crime. So even if she is not pregnant, she comes for vaginitis and she tells that I am exposed to this because of my sexual relation with my boyfriend, you are supposed to inform the police. It is the intercourse which we are informing to the police and not the pregnancy.
No, if she's married, and
But
it's
if
consensual sex.
Yes. Now I will tell you one more thing. There is a case of Independent Thought versus Union of India. They filed a case in the Supreme Court saying that after the POCSO Act, because, see, I will explain this. This is a very interesting thing. In the section 376 of the Indian Penal Code, they have given certain exception. They have said any intercourse with the wife between 16 to 18 years of age is not a rape. Right? That definition was given in the Indian Penal Code. While POCSO Act said that anybody who is having sexual intercourse, any child who is less than 18 years of age, that is a rape. So Independent Thought versus Union of India filed a case in the Supreme Court saying that how marriage changes a status of a girl who is less than 18 years of age. If she is sexually harassed without getting, when she is not married, how come marriage changes it to a normal thing? The crime will remain crime. If it is a crime to have sexual intercourse with girl less than 18 years of age, it should be even if there is a marriage, because marriage also below the 18 years of age is an irregular marriage. It is not a regular marriage. So how does that change the status of a girl? So the court gave decision that even if she is married, it is a crime, but they also have given one exception. That was there in Indian Penal Code section 376 for rape also. That if the girl is less than 16 to 18 years of age, in between 16 to 18 years of age, there was a relaxation. If she is married between 16 to 18, it was not a crime. But less than 16, if she was less than 16, then the court, the section IPC said that if she is married for more than 1 year, then also it should not be a crime. So here the Supreme Court said that if the girl is less than 18 years, if married more than 1 year marriage time, then it is not a crime. But if she comes within few months of marriage or within 1 year of marriage, then it is a crime. So you have to report if her married life is not more than 1 year and less than 18 years of age.
Yeah, can I just ask you a question in continuation? So prescribing contraception to less than 18 is a crime by us?
No.
Then
You
you are allowing her to have sexual intercourse. You are prescribing contraception.
Nice question. But the thing is,
Yeah.
prescribing contraception, we are not giving anything to the victim. She's a victim. See, if it is a crime, she will become a victim. You cannot abet the victim. You can always abet the criminals. You understand? In criminal law, you can abet the criminal. By prescribing her a medicine, you are not abetting a crime, as long as you are not giving it to the boyfriend that give it to your girlfriend and have sexual intercourse. We are giving it to the girl. You
Then we are
cannot abet
encouraging
the
her
victim.
to have sex.
Yes.
Pardon? So
We
what?
are encouraging her to have sex.
See,
Then
it is
under
like
18.
if I am giving somebody a bulletproof jacket, that means I am instigating a murder. It is not so. You understand that there is a difference. If I prescribe somebody bulletproof jacket, that doesn't mean I am telling some other person to commit a crime of murder on him. So by prescribing OC pills to her, you are not instigating anybody to have a rape, to cause a rape to her. You understand that there is a difference.
But you are encouraging her.
If you are giving condoms to a man to have intercourse with a minor girl, then you are instigating a crime.
Well, if you are giving condoms to a less than 18-year-old, then probably the same with the girl also.
No, girl will become victim in that case. You understand? Girl will become victim. She is rape victim. She will not be the offender. Prescribing anything to the victim is not a crime. Giving any instrument and equipment to the offender is a crime.
Okay. Yeah. Okay. Yeah. We have got few more questions which are hanging in the chat box for a long time. POCSO's final report to be given by whom? CMO, gynecologist, forensic medicine, pediatrician, whatever. Is only gynecologist responsible for complete examination and reporting?
Yes, doctor.
Or is it
Naturally, doctor will have to write the report. No, doctor will give. In government hospital, sometimes the CMO and all they countersign because the requests come to the CMO. They refer it to gynecologist, but ultimately the one who examines is responsible.
Okay. If a patient needs urgent procedure and she is less than 18, for example, it's an incomplete abortion or something like that, and if it is an emergency, can we inform the police later after doing the procedure, or do we have to inform the police and take her up because it can be a medical emergency?
Only emergency in law is life-threatening emergency. If she is bleeding, then you have to do the treatment first. Supreme Court has said in many cases, not only POCSO, even for rape, if patient comes with bleeding, all the formalities you have to do later on. But if it is an incomplete abortion, but she is not bleeding, if it is missed abortion and she is not bleeding, then there is no emergency in that. In that case, you have to inform police first, right?
Yeah. And Dr. Shobha Gudi, Sunita Shikokar, we have given you a chance. Dr. Shobha Gudi.
Shobha? Somebody has asked
Yeah.
which the nearest, which police station should we inform?
See, you have to inform police station near to you. Police has a tendency to send it to the place where the crime has occurred.
Yeah.
But in a Lalita Kumari case, the Supreme Court has said that police is supposed to take zero FIR. And that is up to police to file FIR or not. You are not giving them FIR. See, understand the difference. What you are giving them is the information. And you have to write it in the as simple words as possible. And that is what I do. In my hospital, my wife is still practicing. So one girl came and what I made her write, we wrote that patient, one girl of 17 years of age, name so-and-so, resident of so-and-so, brought by so-and-so, has come with pregnancy of 9 weeks. We are planning to terminate. Kindly guide us for further proceedings. We gave that letter to the police. Let them assume it is rape. So when the police officer received that letter, he was laughing at my ward boy. He said, why doctor is asking my permission for termination? He has become mad or what? So he called us and I took the phone. He said, why you are informing? I said, sir, I heard in one conference, they said, our seniors, they said that you have to inform when a minor girl comes with pregnancy. So I am informing you. I don't know any other thing. I am informing you. You take this letter and we are asking for your permission for termination. He said, go and do it. What doctor, it is your decision. Do whatever you want to do. So I took that letter back from him with acknowledgement and I was planning for termination. At that time, the inspector came and this fellow was boasting in front of him. He said, doctors have become mad now. They are asking our permission for termination. See, he has given this letter. And the inspector was knowing this. He immediately called me. He said, doctor, don't do anything. I'm coming with my team. He brought that constable also. And they took the opinion, this statement and all. And he said, I'm taking this girl at home and I'm taking this family with me and I'll take various statements. And then we will bring her back to you or we will send her to government hospital. So this is the implication. You have to inform. Your duty is just to inform. You don't have to become judgmental. It is rape or this or that. You just have to say she is pregnant. You are not even telling there was sexual intercourse. You are just telling she is pregnant. That's it.
Sorry.
Hello.
There is another question.
Hello.
Yeah.
Yeah,
Please, Shobha.
yeah, Lata, thank you. So Hitesh, Dr. Shobha Gudi here
Yes, madam.
about contraception, Hitesh. So what has happened is that after a lot of deliberation from the committee, you know, what we propagate and what we have taken the stand is that prescription giving for contraception can happen only after the woman has made a choice for the contraception. She has to choose contraceptive from a basket of choice and she has to choose to become sexually active and adopt the contraceptive method. So that indirectly implicates that she is going to have sex and we know about it. We have the knowledge about it. So ultimately, because POCSO Act is not clear about contraception, they don't even mention the word contraception. So what happens here is we can get implicated that we are knowledgeable about the fact that she is going to have sex.
No, madam.
So we
Again,
have offered her contraception.
No, madam. Again, I will tell you one more thing. We are supposed to inform the crime after it has happened. You understand that?
But
Here,
it will
the crime has
happen.
not happened.
Here, yeah, but it will happen
So
once the prescription
we are
is
not duty
given.
bound. We are not duty bound. So you understand?
No.
Purchasing a knife doesn't mean that you are instigating a murder. You have a good lawyer in that case.
No, there is a difference between knife and murder happening and contraception and sex.
So there is no difference. You can always prescribe confidently oral contraceptive pills to a girl less than 18 years of age without getting implicated. That I take my words, and if some problem comes, I am there to save you. 100%
So
I will take it.
let me
If
just
somebody is
complete.
giving you this message,
Yeah,
it is
yeah.
wrong on 2 counts. First thing, we are not giving anything to the criminal. You understand, in criminal law, the definition is very clear. You have to abet the criminal. You cannot abet the victim. There is no section which says that abetting a victim is a crime. Right? We are not telling her to become a victim. So
Just
that
a
is-
minute, Hitesh, just
that is
a minute,
out of
just a minute.
reach.
Let me just
Yes,
complete.
tell me.
Let me just complete what I was saying.
Fine.
So we have finally taken a stand that we will counsel for contraception completely. And we will make the girl aware about the POCSO Act. We will make the couple aware, because believe me, the couples are not aware about POCSO Act. I think if they become aware, young couples, they will not indulge in sex before 18. If they know, they will not.
I don't think so.
Or at least no, but at least they will know. They will know about the act. They don't know.
One
That is
more
what I'm
thing I
trying
will
to
tell
Yeah,
you.
They
in
don't know.
continuation to
They
that
don't know.
I will,
They
I will
don't
tell you one
know.
more thing,
Ah.
madam. One more. You understand? One more thing. Don't take too much responsibility on your head. We already have a lot. See, when the law is passed by the parliament, it's in any law. So you are not supposed to inform them about the law. Wherever you are supposed to inform, it is mentioned in the law. Like in PCPM, it is mentioned that you have to put the board that sexual the detection of sex is a crime, and we don't do it here. We have to put such board because there is a mandate in the law, and we are doing it. In POCSO Act, it is not mentioned that doctor is duty bound to inform a minor girl to say that
No, it is not there. It is
So
not
why
there.
they are taking
My
See,
only question is, if we don't inform, then who will inform them? Because when they
already
come,
parliament has informed. See, you understand, madam, when law is passed by the parliament, it is put in the government gazette. It is presumed that every citizen of India knows about it. That's it. Nobody has told me that murder is a crime. I cannot say in the court that I did not know a murder is a crime. I just killed my wife. You cannot say that because it is presumed. It is presumed
but it's
that
a new,
one-
it's a new
Sorry,
fact.
can
It's
we-
a new
can we
thing,
move
Whether
Hitesh.
on?
new or old, there is no such
Yeah.
differentiation.
Okay,
Once it is on
Can
Hitesh,
we move on?
one last thing.
Shubham, there are
One-
quite a
Once it is
few
on the
questions.
gazette,
Sorry.
madam, wait.
Thing.
Yeah.
One
Once-
last
Once it is
thing
on the
from me.
gazette, let me
One
give
last
the
thing,
final
Hitesh.
message.
If a
that
girl,
Wait,
once
Shobha, wait.
the law is on the gazette, it is necessary for every citizen of India to know it. And we have to refer the gazette daily. There is gazette.noc.in. There is a website of government. And we have to check that daily to see whether new laws have come or not.
okay, point well taken. Point well taken, Hitesh. Point well taken. Just one last from my side, Lata, please. If the girl is 19 or 20 or more than 18, but the boy is 17, this is what we come to know. What should we do?
Then also, see, if that is harassment of him, it is sexual harassment of him.
Gender
And we have to inform.
But Dr. Hitesh, Lata, only one point here. Dr. Hitesh, in the POCSO Act, as far as the accused is concerned, everywhere it is written he only. Though it is supposed to be gender
Unfortunate.
neutral,
Because,
as far as the accused is concerned,
because you don't know the IPC. If you read IPC, they have mentioned that whenever he is mentioned, she is included.
Okay.
In law,
Right.
it is mentioned very clearly. There
Yeah,
are
okay.
general clauses. You have to read the general clause for that.
Does
So whenever he is mentioned, she is included.
consensual sex under 18 amount to a crime then? Because it keeps happening. So do we keep informing?
Yes,
Yeah.
definitely. See,
Okay.
there is
Fine.
judgment from the Chennai High Court. Chennai High Court has said that biology works, and we cannot control biology by law. But
Yeah.
since this is the law, we are constrained to give punishment to the couple who are in a love or romantic relationship. And they had given a punishment of certain amount of jail to the boy. They say we are constrained to give this. And we will request the parliament to make necessary changes in the law. But it has not happened. But they have to pass a judgment also. Even with the heavy heart, they have to pass.
What if it has happened in the past?
Pardon?
What if it has happened in the past?
Past means what? When?
For a couple of years back.
Yeah.
Law is always progressive. It is applicable from the day it is passed,
2014.
not the retrograde.
Yeah.
There can't be retrograde effect.
There is a question here in the
Yes.
chat box. Now we are seeing her for the second pregnancy at 21, but she had her first child at 17. So what do we do? I think you have
1
answered
year
the
of
question
marriage.
before. Yeah.
So she was married or not married?
She was married.
So marriage is more than 1 year.
More
or
than 1
everything
year,
has
you have
to
answered
pass
the
more than
question.
1 year, we are not supposed to
Yeah.
inform.
Yeah,
That
you have answered that question. See, I have a question. I saw a girl who was brought by her mother, who was applying for divorce. And she said that father abuses her regularly, and it was hard to sort of believe it. But she brought the child with some scratches on the in the perineal area and thigh, etc., and also some I mean, odor of semen, etc. So I mean, this child, I don't think it was abused. But when they come and say that, what do we do?
See,
Because
when-
she is applying for divorce on these grounds, very likely.
No, see, when there is such complaint, let the police decide. We are not.
So we can't, we hand
We have
the
to-
case
When
over
one
to the
of the
police.
parents says that my child is abused, you are duty bound to inform. We are not investigating officers.
Yeah.
Investigating agency is
Sure.
the police. Police will take out the fact.
Fine. Yeah, that's all. I mean, I wanted to know whether,
there is one
even if
person-
it is a hearsay or a false, this thing, because you yourself said that there is an act that if falsely you are informing the police, I mean, like that there is semen, there is scratch marks, etc., which
Even if
might
there
not
is
be
nothing,
committed by.
even if there is nothing, there are no physical marks, right? They say trying to do so is also a crime. It is
Mm.
not only a physical abuse. Even if they're trying to do so, that is also a crime. If somebody is trying to touch vagina, trying to touch anus, trying to touch this, that also is a crime as per the definition. That is why I read the definition.
Intent
Now,
is
if somebody gives you
Intent.
information,
Intent.
so what section 19 says, if you have a knowledge, they don't say if there are physical signs. What it mentions, if you have a knowledge that the child is abused, you are supposed to inform police. That's it. So when somebody tells me, I get the knowledge that this has happened, I'm informing the police. Now police will inquire whether it is truth or not, it is hearsay or it is a fact.
There is a
Yeah,
question in
okay.
the chat box which says that a girl less than 18 takes MTP pills from a pharmacy and then comes to us with bleeding. So do we still need to inform the police?
100%. I will give you one example here. There is Dr. Jesse Joe or something from the Kerala versus Union of India. Now, what happened in that case versus state of Kerala? Yeah, it started with there. A girl who was 18.5 years of age, 18 and a half years of age. She was full-term pregnant and she had fetal distress. A cesarean was done. And it turned out that when cesarean was done, she was 9 months pregnant. Her age was 18 and a half. So when she conceived, she was less than 18 years of age. So doctor, pediatrician, and anesthetist, they all three were arrested. And they lost the case at Sessions Court. They lost it at the High Court. They went till Supreme Court. And the Supreme Court said that in the emergency, when the child has fetal distress, it is impossible for doctor to calculate that when she conceived at that time, she was minor. It is doctor's concentration will be on the biology and medical part rather than a maths. So doctor will not do mathematics at that time. And that is why doctor is not informed. So we are letting him go. So they gave this acquittal to the doctors. But they said we should not be misquoted that such incidents should not be reported. You are duty bound still to inform. This judgment will not become precedence. This is just a benefit given to these three doctors who were in an odd situation where it is impossible to calculate when you are dealing with a emergency.
Yeah, similar question in the chat box. If a patient comes for a scan at 18 and a half years of age and she's 5 months pregnant, how
Same
do we
thing.
go about it?
Same thing you have to inform.
Yeah. The other thing is, if I mean, you consider this as, I mean, it looks like an infringement. We are exposing the patient's information to police, etc. But it's a paradox, isn't it?
Professional secrecy.
Yeah.
Let me tell you.
Infringement,
one more
yeah.
thing. What is infringement? What is infringement? Infringement doesn't mean giving information to the state is not infringement. There is a concept of that a state is parent of every citizen, and state is child also of every citizen. I will give you an example. If nobody is there, state is your parent. When somebody is not there, the government officer will give consent for something, right? So government takes your responsibility. If somebody dies without anybody, then government will do the last rites for that particular person. So government is a parent as well as government is a child. If somebody dies without making any will, the property will go to the government. So disclosing the information to the parent is not a crime. So giving information to the state is never an infringement of privacy, and rather it is a mandate in the law. It is said that you inform us. So it is never an infringement. You have to do it because you are duty bound to do so.
There's one question here. If case registered and documentation is done in a different place or hospital, and the patient is shifted to the other hospital, do we need to inform again?
See, you have to inquire whether they've informed or not. It is same like MLC case. If they have done MLC before, or if they have done it, you just mention the MLC number or information. You take the Xerox that they've already informed. If not, you have to inform, because all those who have information are supposed to inform the police for the such incidents.
If we did not examine a child or somebody less than 18 who under POCSO, who is coming under POCSO, what would be the punishment for the doctor? Because I might be busy, I might not be able to give time on that particular day.
You have to, there is, it is, the punishment is under IPC also. For sexual assault victim, you have to examine and you have to give the treatment. So both things are there. If you do not do it, there is a punishment, I think up to 6 months to 1 year of imprisonment.
Right. And if a child is shifted from our hospital to another government setup or something like that, do we still inform the police and then shift the child?
Yes. You have knowledge, you have to inform.
Okay. Now, if the girl is married between 16 and 18 years when pregnant, why do we still know? If she's married between 16 and 18, he's been telling the same thing. If the girl is married between 16 and 18 years when pregnant, why do we still need to inform?
Because there is court judgment, independent thought versus Union of India. They have said that that particular section from the Indian Penal Code 16 to 18 is struck down by this judgment. They said you have to inform, even if she is married.
Even if it is more than 1 year.
If more than 1 year, you are not supposed to inform.
That's what.
Dr. Hitesh, according to the POCSO Act, it is, I mean, I read somewhere that if you do get a girl for termination of pregnancy less than 18, you inform the police and then you go ahead and do the termination. That is what somebody, Dr. Jaideep was saying the other day. So if we were to do that, do we need to collect the abortus for DNA and all that stuff? Fortunately, in my case, the patient didn't come back to me at all once I informed the police.
What we are telling is, we tell as I told you, you have to write in the application only that I am planning to terminate the pregnancy on this date, this time, kindly advise us further. If you do not get any advice, you can go ahead and terminate, but it is your duty to keep the sample. Again, after termination, you write a letter that we have terminated the pregnancy as informed before, and now the sample is there with us. Kindly collect within 72 hours. If they do not come and collect, you dispose the sample after 72 hours. Don't worry.
Okay.
Okay. So you will have to keep the abortus.
Yes.
And how do you preserve the abortus?
After 72 hours, there is very less possibility to get DNA.
It's not for DNA.
It is not for DNA analysis, isn't it? So we keep it in formalin.
No, but then it is, I believe they do a DNA analysis.
You will keep the sample in a normal saline for DNA.
Not in formalin.
Not formalin.
Not in formalin, because that police did tell me that in the government hospital, they'll collect the abortus. I mean, that girl went to the government hospital for termination, taken by the police. And he said the abortus will be sent for DNA to find out for a paternity
DNA test to find out the paternity, to run the paternity test.
Right. Dr. Dara Meena has raised her hand.
Yes.
Meena, Dr. Meena.
Hello, sir. Good evening. Sir, is it necessary to register under MTP Act to prescribe MT pill for 9 weeks?
Up to 9 weeks, I already told, I have answered this question. You can have an access letter and you can do it.
Yeah. Okay, I think we have had very good discussion. Thank you very much for
Wait,
all the
Lata,
inputs.
1 second.
And I mean, you repeatedly say how vulnerable we are. So I think BSOG should have a team of advocates, probably.
Those who know medical legal subject, that is the most sad part of it. The incidents which I told about Mumbai, even in city like Mumbai, that girl, that doctor, she told many of the office bearers and many of the advocates that now I came to know that this girl is minor and I have terminated her pregnancy, what to do? Nobody advised her properly and she was ultimately taken into police custody. There was a good 4 months time. She could have been advised appropriately so that she would have avoided that particular thing.
What was the outcome?
I told we got her bail on 14th of January, that is 3rd day, because she came previous night and next day I got her bail. That is first thing. And second thing, just 2 months back, we got a beautiful judgment discharging her from this particular offense.
Wonderful.
Dr. Hitesh, how many cases of doctors being imprisoned or punished for the POCSO Act? Like, how many situations have been there where the doctors have been really put into trouble because of not informing?
Madam,
Approximately.
you are asking about my practice. There are so many such cases which I am fighting
Okay.
all across India. Right? My entire practice is dependent upon that because I don't take patients' cases. I take only cases to save the doctor or from the doctor's side. So my entire practice, and I have left my gynec practice. I have become advocate. I have registered with the Bar Council only because I could not cope up. So I had to do that. So I have become advocate now. So that much is the practice. It can make one person survive on that. That's it.
Yeah, do you run courses, short
And
courses for
yes, we are
obstetricians?
starting medical legal course. We have already
Seriously?
started with one Delhi gynec forum also.
Yeah, I think
and
so. I think it's very important to feel equipped.
yes, at least you should know the law.
Yeah, thank you. And wonderful discussions.
OTC here in Bangalore. In Karnataka, we still don't have regulation like in Maharashtra. There was a question.
What regulation is not there?
No. They can prescribe, I mean, without a prescription, MTP pills can be taken as an OTC drug. In Karnataka.
MTP pill is not a OTC drug. MTP pill is not a OTC drug.
Not, it is not, we know.
But here it is. In Karnataka it is.
So they are doing crime. Those who are giving, they are giving crime. There is punishment up to 7 years of imprisonment.
How do we tackle that?
See, there are so many crime, madam. Why do you want to tackle? It is police's job. They will do it. You can inform police. You can become informant.
Yeah.
Your nearby neighborhood pharmacy.
See, this MTP Act is 1971.
Yeah.
There is 1860 Act, Indian Penal Code, where murder is a crime. Still murders are happening, right, in the town. That doesn't mean it is allowed. You understand that? If something is happening in spite of law being in place, that doesn't mean that it is allowed. It is still a crime. And if you have that much time, free time, you can inform police and you can go to the police station, you can attend the court and you can help the law.
One last question, Dr. Hitesh. See, there are quite a few people who have been asking, when there is a question of termination beyond 24 weeks, we need to put it across the medical board. Now, there's a question which says that medical board can be formed only by the team of doctors from government hospital, or it can be any medical board.
They have said government board will be having this many doctors and it will be gazetted by the state government. So state government will put anybody's name. It can put private practitioner's name, any other person. So you must have seen the constitution of the board, right? Gynecologist, radiologist, pediatrician, and any other person which government may deem fit. So they can put anybody on the board. It is up to the government.
Supposing I have 1 second. Supposing, because there's somebody has this question. Supposing I have a case of needing termination of pregnancy beyond 24 weeks. Who do I write to now? Since
your authority, your appropriate authority in your area, you just tell them that where is the board and where should I write this to? Or you can put an RTI that kindly give me the gazette of the medical board constituted under MTP Act 2020. So they will give you the copy of Gazette and you will come to know the name of the doctors. who
We
are-
have to contact the DHO.
Yes, either DHO will give you information directly or you
Yeah.
can put an RTI and he will give you
Yeah.
information that where is the board and who
That's
all are the
exactly
members.
what I did.
Last question. I
Hmm.
think Dr. Shobha has raised her hand again. Can we be brief? Because
Yes.
we have run beyond time, actually.
Yes.
Thanks.
Shobha, quickly.
Shobha,
She's happily smiling away. That's it.
Okay. So thank you very much, Dr. Hitesh, for that wonderful session. I mean, we enjoyed again asking you questions, getting really bullet-like answers. So wonderful. We would like to have you again and again, but I know how pressed you are for time, but we are very grateful to you for educating us on this very important topic. Which is
courses when they start.
I think we would be very eagerly looking forward to sort of join your courses, make it a certificate course or whatever, a week's course, weekend course, whatever. So please do. And we would like to, like many of us,
Yes.
Our main aim is to make doctors very strong,
yeah,
doctors knowledgeable in the law, so
Knowledgeable.
that they don't fear. My entire aim is to have fearless practice. That's it. So
Dr.
doctors must have
Hitesh,
fear-
before we wind up, I want to say that we have given instructions to the people of the web platform to record this meeting. So do we have your consent for putting up in the BSOG website of a circulating this?
Always.
Yes, you must raise your hand. They have recorded and they're taking your consent now.
This is affirmation. Consent is always before. This is affirmation. But it is fine. I have no-
yeah. Okay.
Good. That's a good one. Hitesh, that's
And
a good one.
it was very well attended, nearly 125 participants.
Yes,
were
yes.
there.
Very well
And very
attended.
heartened. And
Very well
so that
attended.
speaks about your popularity. Thank you
Yeah.
very much again.
Pleasure.
Yeah,
Thanks.
yeah.
Thank
Yes,
you.
yes.
Yeah.
Thank you.
Sorry, Dr. Sudha Benpatti and Shobha, for not taking the
Shilpa?
last two questions.
Shilpa,
Thanks.
Yeah.
Thank you, BSOG, for
Giving us the
giving
platform.
us the great opportunity of interacting with Dr. Hitesh and with interesting questions and interactions. Thank you very much. And a very interesting topic. Shilpa and team, thank you.
I want to say that recording of this will be available at the earliest. I will ask those people, and then this can be put up in the BSOG website so that anybody who wants to know a little more about this can have access to it. Thank you. Or they can contact Suchitra. Thank you, Dr. Hitesh.
Thank you. Thanks, everybody. Thank you.
Bye.
Thank you, ma'am.
Thank you, Shilpa.
Thank you, Chitra. Thank you very much.
Thank you, Suchitra, for hosting this meeting. Thanks.
Bye.